This is a hearing today. Mr. and Ms. Eppinger, you have filed a motion alleging that the consent judgment that was entered into in this case back in 2021 has been violated in some way by the Longs. Is that correct?
Yes, Your Honor. The Morowskis are also here.
I'm sorry, who's that?
Morowskis are also on the suit.
William and Rochelle.
William and Rochelle Morowski are also on the suit in the motion.
Oh, I see. Okay. I don't see them connected today.
They're here with me.
Oh, they're present there with you?
Yes, that's a Shelley Morowski next to me.
Okay. Oh, I'm sorry. I thought that was Carrie Eppinger. I don't know any of you by appearance. So. Okay, so your side's represented by the two of you. All right. So this is a motion to enforce, and so generally what I do at these types of hearings at the outset is just try to determine whether there is some type of controversy here that needs to be resolved by an evidentiary hearing. I did have a chance to go through that consent judgment back from 2021. There's a lot of information in that judgment about how things were supposed to go forward. And Mr. Eppinger and Ms. Murakowski, I mean, I know what you guys submitted. I guess what I'm looking for maybe is some clarification. Number one is as to why you filed this motion now. And number two, what exactly do you believe that the Longs were supposed to do under this judgment that they're not doing or that they're violating? Because there's a lot of provisions in there, and your motion isn't clear to me exactly what you're saying that they're doing wrong.
This is Tim Eppinger. What we have is they're not, most years they don't even put in their fair amount of dock. We put in 50 feet of dock each year until this year, where we were only be able to put in 20 feet because of the depth. And I believe they put in 74 feet total. There's like 94 feet out there, which is adequate at the moment. And years previous, starting in, well, they haven't put in their fair amount of dock most years. Also, we have the kayak issue where each of us is allowed one watercraft, and they put 2 kayaks in along with their pontoon, which comes to 3 watercraft. And they also put in a lift, which is not allowed the last 2 years. Also, they're not following the lottery because we don't know why they don't follow the lottery, which is also in the consent judgment.
I hope he's on the road.
Okay. All right. And when you're talking about the length of dock, are you saying they're putting in too much dock, not enough dock? Can you explain that to me?
The Moroccan would like to put their boat down there most years, but to float it, we need more length of dock because, you know, you'd have 2 pontoons, considerable size on one side. And as the summer goes along, the water gets a bit shallower. So you need a considerable amount of dock. Approximately 100 feet of dock would be sufficient. So if we each put in 50 feet of dock, that would be great. As far as the dock.
Okay, and you're saying before they didn't put in enough, they didn't put in their 50 feet. Is that what you're saying?
Correct. And you can see by each illustration of the years from 21 to 26. 21, you can see the wood top dock is ours, which has all been redone. We put in 50 feet every year, except this year, where our stanchions weren't long enough. We put in 20 feet on the end of theirs. And I don't know why they put in so much. Sometimes they put in the 30 range of feet. It's been in the 26 feet before. I mean, 28 feet they put in 2025. 24, they put 26 feet in.
Your Honor, this is Shelley Morosky. In 2024, no dock was put in whatsoever by the Longs. And in the mail we received from their new attorney, it wasn't Dave Biganowski who handled the dock. It was from James Burnett, saying that he's taken us for litigation on the dock. We had already gone through litigation and you had already signed the consent judgment. We had to get our attorney on the phone and ask, where was Mr. Long's dock? After the fact, after our attorney responded to him, then they put some dock in. But he took his boat out there and hooked up without putting any dock in, which brought our attorneys back into the situation as far as writing them a letter to ask. Apparently, I guess the Longs did not inform Mr. Burnett that there was a consent judgment. And Mr. Burnett threatened us with litigation if it wasn't followed. And Susan Jill Rice from Elward and Fisher is the one that responded. And I do believe Mr. Eppinger included that letter in the packet.
Okay. All right. So I think I understand a little bit better now. Mr. Larkin, what is your client's position?
Thank you, Your Honor. First, I just want to say that there doesn't appear to me to be any actual evidence provided in support of this motion. There's a chronology, but there is nothing in here that substantiates any of the claims of violations. And there's no evidence to substantiate any of the claimed violations. There are photographs that are not contextualized or explained. Moreover, none of the things that are stated in this chronology, and it is broken down annually, 2021 through 2026, actually, to my eye, constitute violations of the consent judgment. They say, in 2021, Long contributed 20 feet of dock. In 2022, Long installed 32 feet of dock. The defendants here have not explained why or how that is a violation of the consent judgment. The consent judgment, nowhere in the consent judgment does it say that the length of dock is to be split evenly. It says that costs related to the purchase, replacement, maintenance, and repair of the dock are to be borne equally. Now, it's my understanding that the only costs for the last 5 years associated with the dock have been borne by Karen and Archie, my clients, who pay to have their portions of the dock installed. The Eppingers, I understand, install their dock themselves. So to the extent that the Eppingers are alleging that there was something violative of the consent judgment by the amount of footage that my clients put in, I don't see any evidence to substantiate their claims of how much my clients put in, and B, I don't see anything in the consent judgment that compels my clients to put in a specific number of feet of dock. The next thing, the other thing I want to say, Your Honor, the consent, the Eppingers and the plant defendants, I should say, talk about the kayak issue. Again, nowhere in the consent judgment does it say that my clients can't have two kayaks, that a kayak constitutes that a kayak is equal to one boat. Nowhere does it say my clients can't have a boat lift. I mean, if you look at the photograph, Your Honor, of the boat lift with the kayaks, it is the size of one boat. I'm going to submit to the court that my client's installation of a little lift, probably smaller than one pontoon boat in one of their spaces, does not constitute a material breach of the consent judgment in any way. The consent judgment does contemplate a 3-boat limit, but it's my understanding that is for the other dock. There are, of course, 2 docks located on this parcel, and the one that says parcels E and D, those are not my clients or the defendants, from what I understand, shall not locate more than 3 boats. That is a different dock than the one we're talking about. Okay. So I'm going to submit, Your Honor, that there's been no evidence in support of this motion brought by the defendants. B, there is no, even in the chronology that they've put forth, there is no allegation that I can see that violates any of the plain language of the consent judgment. C, none of the relief they requested has a basis in the consent judgment or a basis in the law. They've asked, of course, for a 1-year suspension of lake easement for every year violating the consent judgment. That's not something that's contemplated by the consent judgment, that kind of a punishment. Permanently have Eppinger and Murawski on south side of dock. I know that the Eppingers did just briefly there mention communications from Mr. Burnett. I believe in one of those communications, he proposed that and never received a response. So I don't think there's any legal basis for any of the requests for relief. I see no evidence in support of the allegations. I don't even see anything alleged that actually violates anything in the consent judgment. And for that reason, Your Honor, I would ask that this motion be denied. And as I'd also just like to state for the record, there is this other document that I received, which purports to show a legal history with the Longs. None of that is, should be, I don't think, adjudicated in this matter. If there are other causes of action or claims that the Eppingers or the defendants believe they have against my clients, Your Honor, there's a proper forum and way to litigate those things, but those have, no value or relevance whatsoever to this claim that there's been a violation of the consent judgment that was entered in 2021.
Okay, Mr. Eppinger or Ms. Murakowski, how would you
Yes, Your
respond?
Honor. Item number 14, there shall be no shore stations or boat hoist allowed by any parcel owner, including for jet ski, because it's a 74-foot easement. And also no mooring of any boats on a communitized dock. A kayak is considered a watercraft. Although Longs have 2 parcels, they get 2 watercraft put there. And Murawski's and Eppinger's get 1 each. Shall we have a?
Yes. Also, Your Honor, saying that we did not respond to Mr. Burnett's information regarding what he proposed.
I
Our attorney responded.
Honestly, I don't care about Mr. Burnett and that whole thing. That doesn't matter
Okay.
to me. What matters
But
to
there
me
was a
is whether or
response.
not, what matters to me is whether or not what's happening out there right now. And we didn't have any motions in prior years. So I can't, I'm not going to be making decisions about what or didn't happen, what has or hasn't happened 3 or 4 years ago. So what, if there's violations, then it needs to be brought to the court at the time the violations are occurring. Those things, if it happened in 2022 or 2024, that's all water, under the bridge, so to speak, at this point. So what I can decide is if there's something happening now or this year that's been a violation, then I think that that's something the court needs to take a look at. And so when you talk about the footage issue, where does it say, because I am looking at it and, it talks about bearing the cost of the communitized dock equally, but I don't see anything in the consent judgment about everybody has to put out a certain number of footage. So can you tell me where you're relying on that?
Well, it says, Your Honor, each party will contribute 25%, and Longs would be 50% because they have 2 parcels, and Eppingers and Murawski's would be another 50%. And we're putting in 50 feet. Now, for them to put in a pontoon, there needs to be approximately 100 feet of dock out there, which is there almost is now. And it makes it so all parties can use that shared dock. And also this year, there's still the lift out there and the extra, the 2 kayaks on a lift. And a kayak is considered a watercraft craft under Michigan law. And also, last year they didn't follow the lottery, but I know you said you want this year, so they're not even following the lottery instructions that are in the consent judgment to hold a lottery, but it's kind of hard to hold a lottery when there's the TPO against the Longs. Archie Long, pardon me. So you can't meet like you would, but he's never showed up for a lottery anyway, so. It would definitely make it easier to be on the left side of the dock, having two pontoons to get out and in a lot easier when they only have the one pontoon at this time and just having kayaks down there. It'd be easier for them to be on the inside.
If I may, Your Honor.
Go ahead.
Thank you. I don't see anywhere in the consent judgment where it says the percentage breakdown of how much dock is to be contributed. Moreover, I believe at the outset, Mr. Eppinger's opening comments, he said that the amount of dock that the Longs have contributed this year is more than sufficient. Of course, I think he says it looks like in May of 26, the Longs installed 64 feet of dock and an additional 10 feet of dock. Now, if we're looking at 100, that would be 74 feet of dock total. That would be more than sufficient, even using their percentage breakdown. As for the 3 boats and the boat lift thing, again, those provisions in the consent judgment talk about the 74-foot dock, which is a different dock than the 79-foot dock that we're talking about. Moreover, Mr. Eppinger continues to use the word watercraft. Boats and watercrafts, that is a distinction, I think a meaningful distinction. The 2 kayaks on the lift take up no more space, as you can see in the picture that Mr. Eppinger produced, no more space than would a normal boat. I think it's, frankly, not, I don't think it's, an appropriate or worthwhile thing to litigate here, whether or not 2 kayaks, somehow violate the consent judgment. They're not taking up any more space than a normal boat would. I don't know why we have to litigate that. That seems more punitive than anything. And lastly, as for the lottery, the Eppingers have taken out a PPO. And if they cannot, on one hand, take out a PPO against the Longs and then also say the Longs are refusing to participate in the lottery. I mean, we have to obviously figure out some way in which to conduct the lottery that it comports with the terms of the PPO. And we're happy to explore that. I don't think today, obviously, is the right forum for that. The Eppingers didn't request that as any type of relief or didn't move for anything related to the way in which the lottery is conducted. So for all those reasons, Your Honor, I would ask that this motion be denied.
All right. Here's what I'm going to do. And it kind of goes back to, I guess, my original question and my original kind of difficulty with considering this is I think there may be grounds. I think there are certainly some issues here potentially with the way that the Longs have been operating in relation to the consent judgment. But I don't think it's been properly identified by this motion if it does exist. And so Mr. Eppinger and Ms. Murakowski, I guess what I'm going to do is to the extent that the 2 of you want to continue to pursue this, I'm going to require you to file another motion that is more specific than what was filed. And by that, I mean, I need you, and one thing that you have to understand is for me as the judge from a legal standpoint, I have to go by exactly how things are written, not how people have interpreted them, and so forth. And so, and any kind of decision I would make would have to be based on the language in the consent judgment as it's written. So what I would need you to do is point out exactly which paragraph and identify that paragraph in the consent judgment that you believe has been violated, and then provide the basis for why you think it's been violated. And then I think I could consider it. As it stands right now, because it sounds like there are multiple docs out there. Your motion references specific feet. I think Mr. Larkin makes a good point. I mean, there isn't any reference of percentages or feet in the consent judgment. If boats or hoists are placed on one dock, it may not be appropriate, but it might be okay on the other dock. So that's why I just need much more specificity from you to the extent that you want to pursue this than what I have now for me to be able to make a decision. So again, I'm going to deny the motion without prejudice. That just means it's not a final decision on the motion. Mr. Eppinger and Ms. Murakowski, again, if you want to refile it, identify again the specific paragraph of the consent judgment that you feel has been violated and why it's been violated. I'd be happy to consider it again. The only other thing that I would tell you, Mr. Larkin may have referenced this, I think he did. The court has certain powers to enforce judgments, and those are called contempt powers. And so I can impose fines, up to and including putting somebody in jail until they comply. That's called a compulsory form of contempt. I don't think it's within my jurisdiction or my power in enforcing the order to, suspend the longs if I did find that they violated the order in some case, in some way, which I haven't. But if I did, I don't think it would be within the court's power, contempt powers to suspend their use of the lake for every year that they violated the judgment. I wouldn't be able to grant the two, your families any more or less or different relief than what's in the consent judgment. I certainly wouldn't be able to award you all of your attorney fees from the prior litigation. That's over and done with now. So essentially what I would be, limited to is potentially issuing fines, issuing orders compelling them to change whatever they've done out there that's in violation or to come into compliance with the order or the consent judgment, and potential fines associated with that. But that's really the power of the court here is to make them comply or to remove things that are not in compliance. Not necessarily to punish them in the form of, suspending their ability to use the dock and that kind of thing. I could punish them by imposition of fines, but again, that wouldn't be related to, your attorney fees and so forth from the previous action. So I just want to make sure that you understand that as well, that I certainly have a lot of powers at my disposal through the contempt powers of the court, but it's not unlimited. And some of the things that you were asking for are things that I just wouldn't be able to do. So Mr. Eppinger or Ms. Murakowski, do you guys have any questions about how I'm ruling today?
No, Your Honor. We filed the motion.
All right. Mr. Larkin, anything further from your side today?
No, Your Honor. Would you like my office to submit an order?
I'm going to prepare one just for the reasons stated. I don't want your clients to have to incur fees for you to do that. So
Sure.
That's something the court will do.
Thank you, Your Honor. And then just with respect to the with prejudice, without prejudice distinction, are the violations from pre-2026, are those being denied with prejudice? I know you said you didn't want to, you didn't think that those were, properly before the court.
Yeah, that was more of a comment or dicta. That's not a ruling. And the entire motion is without prejudice at this point. I don't know that Eppingers and Murakowski's may find a legal theory that would apply or may hire counsel that does. So that was more of a comment.
Okay. Thank you, Your Honor. That's all I have.
Okay. All right. Thank you. Everyone's free to disconnect on this case today.
Thank you, Your Honor.
Thank you, Your Honor.